Ladies and gentlemen, in this, our final session, we will conclude the review of the 6 possible issues of contract law which we might confront on a bar examination. We have 3 of them yet to go, but before we tackle them, let's pause to put ourselves in the big picture. I've indicated that on both the essay and objective portions of the California bar examination, when it's said and done, there are 6 major issues where they're liable to be testing on contract law. The first is the formation of the agreement, and we have covered that. The second is the qualification of a private bargain for the legal status of a contractual relationship, essentially looking for bargain for legal detriment on both sides of the exchange, valuable consideration. The third step, the one we concluded with yesterday, if we found a bargain and we concluded that the private agreement was indeed a contract, we quickly canvassed the facts to determine whether the terms of the contract or the subsequent conduct of either of the parties who had formed that bargain imposed any duties or, more likely, conferred rights on non-traders. Now, in this session, we will conclude our analysis by looking at the following items. If we have formed an executory bilateral contract, our fourth step is to determine the time and order, to fix a time and order for the performance of the promises which the parties have exchanged, and to do that we will use the law of conditions. So the fourth step of our analysis: have the performance obligations created by the contract matured? Have the performance obligations created by the contract matured? The fifth possible issue of contract law: if we have found a contract and it appears that we have a fully matured duty of performance, if factually that duty is not being performed, then we are about to conclude that the trader is in breach. But before we do it, pause to consider whether the contract duty has been excused. So the fifth step in our analysis: to canvass the fact pattern for the potential presence of a doctrine of excusable non-performance. If there is excusable non-performance, a refusal or defective performance is not actionable. Indeed, a refusal to perform is privileged, not a breach. But if no doctrine of excusable non-performance rescues the party with a fully matured contract duty, then his failure, refusal, or defective performance on that contract duty is a breach of the contract. Our sixth and final issue: breach and its remedial consequences. So that's the big picture of what we will accomplish today. Let's begin with the fourth possible issue of contract law. Once you have determined the identity of all persons, traders and non-traders if any, who may have rights or duties on a contract, ask this: have the performance obligations created by the contract matured? Now, that question brings you to the need to fix a schedule under which the performance should take place, and you do it by applying the law of conditions. Right? Of conditions. Now, let me state a couple of major truths. Here is an example of a simple executory bilateral contract. Right? The contract came into existence at the point at which the parties exchanged promises in the process of offer and acceptance. If there was bargain for legal detriment in the terms of those promises, a contractual relationship occurred. But now we must move beyond the promissory stage to perform those promises. And simply looking at the diagram poses the issue: which party, A or B, must perform first? There are only 3 possibilities. Either A must perform his obligation first, B going second in time, or B has an obligation to perform on her promise first, with A privileged to wait and go second in time, or A and B must render their performances simultaneously. Right? Those are the only possibilities. In order to settle the question, and we must settle it in every contract, we use the material of conditions. Every condition modifies a promise. There is no such thing as a condition in the abstract. The condition modifies the promise either by setting up a contingency which must be removed before liability on the promise matures. In a moment we will call that a condition precedent or concurrent. The other potential is that the condition modifies the promise by inserting some contingency, which, if triggered, means that liability to perform on the promise will be discharged. That is the impact of a true condition subsequent. So if you'll simply remember that we must always fix a time and order for the parties to carry out the terms of their contract, that we do it by using the law of conditions, and that the law of conditions always modify promises, I think you'll have very little difficulty with this doctrine. Now, the first step in a four-part analysis is to look at the fact pattern and go through the following inquiries. I want you to take each phrase of the fact pattern and ask yourself this: does it create or condition liability? Here you will be distinguishing the covenants in the bargain from the conditions. Covenants create liability, conditions modify covenants. The second step of your analysis: once you have isolated the conditions, ask this: what is the impact of each condition on the covenant or promise that it modifies? Right? What is the impact of the condition on a present duty to perform the modified promise? Third, once you have found the conditions and typed them for their impact upon the promises which they modify, ask yourself this: has the condition been satisfied? Has the condition been satisfied? Almost invariably, as I'll be talking about this topic in a few minutes, you will see that that's a question of fact. That's a question of fact. The contingency has or has not factually been satisfied in the fact pattern they've given you. The fourth potential issue: if you have found a condition, you have determined its impact, and it turns out to be a condition precedent or concurrent, but it has not been satisfied, then you're about to conclude that the party who had the protection of that condition, that party's liability has never matured, and therefore she is privileged to refuse to perform her promise. But before you are comfortable with that conclusion, ask yourself, has the condition been excused? Has the condition been excused? As we'll see in a few minutes, excuse is every bit as functional as literal satisfaction to remove a condition and to mature the liability of the party who made the conditional promise. Well, we begin with the attempt to distinguish conditions from covenants. Now, this topic traditionally excites apprehension in the mind of many, but it should not. Once you understand the function of conditions, they will be easy to recall and rather simple to apply on an examination. The machinery of conditions was developed by common law judges to serve two key utilities. Each relates to fixing a time and order of performance of the obligations created at the formation stage. What are the utilities? First, at the formation stage, when A and B are bargaining over the terms of a contract, conditions provide the traders with the machinery to accomplish the allocation of risk. Conditions permit people to accomplish the allocation of risk. They are literally the ifs and buts of ordinary conversation. And those risks include the fundamental one, that the party that you are bargaining with and who is apparently so sincere will, on the day you expect him to perform, refuse to do so or defectively perform. And the major risk that you now face is, how does that disappointment affect your own liability to carry out the terms of your promise? You can use the machinery of conditions to shift that risk to the other trader by fixing an order of performance in which he goes first and you are privileged to go second, right? And then making his performance the condition to maturing your liability. So at the formation stage, traders use conditions in everyday life to allocate risk. The second utility of conditions is that they provide courts at law with an ability to assign primary fault or responsibility to one of the parties in a contract which has been breached and which we must now remedy through an award of money damages. You see, there's only one remedy for breach of contract at law, and that is to award money damages to one of the parties. So unlike equitable remedies that aim to make both sides carry out the terms of the bargain, the damage remedy at law presupposes that the bargain has been breached and the contract will never be performed. Right? The response of a law court is simply to order a transfer of wealth from one party to the other to approximate to one of the parties the position he would have been in had there been performance and not breach. But if you think about it, that is a totally one-sided remedy. Right? The remedy at law is totally one-sided. One party receives a transfer of damages, wealth, designed to put him in approximately the position he would have been in had there been performance. The other party gets nothing other than this whopping bill. Now, given this harsh and totally one-sided nature of the damage remedy, for more than 3 centuries, courts have been interested in being very certain which of those parties breached the contract. And we use the law of conditions to isolate the party in breach. Right? Now, I've indicated that your approach is first to go through the material looking for the presence of covenants and express conditions. Let's discuss that. The distinction between covenants and conditions is vital. Covenants determine what must be performed in order to carry out contract obligations. A covenant, therefore, is merely a fancy synonym for the word promise. Conditions, by contrast, determine when and if the promises made in the agreement must be performed at peril of breaching the contract. So failure to perform on a covenant, a promise, when the time for that performance is due, constitutes a breach of contract. But the failure of the facts to satisfy a condition merely means that the conditional obligation never matured. And so failure to satisfy a condition is never a breach of the contract. Now, how do you distinguish covenants from conditions? Usually the language of the question will guide you to an instant decision that it is either language which is creating an obligation, that's the language of a covenant, a promise, or the impact of the language is that it will circumscribe or extinguish an obligation otherwise mentioned in the fact pattern. I call this the balance sheet approach. We go through every phrase in the fact pattern asking this simple question: does this phrase create an obligation of performance which is otherwise unmentioned in this question? If it does, you are still counting up the total number of promises the parties have exchanged. Or does the phrase I just read involve the second mention of that duty of performance? Almost invariably, any second reference in the fact pattern to the duty of performance is the insertion of an express condition. Suppose you use this little balance sheet approach and you encounter a phrase that is ambiguous as to whether it is the language of a condition or that of a covenant, then the examiners are testing you for knowledge of a fundamental rule of contract construction. Doubtful or ambiguous language is always construed as the language of a covenant, a promise. It is never regarded as the language of a condition. That judicial attitude protects the interest of the other trader. You see, at the formation stage of a bargain, I am free to hedge my promise to you to my heart's content by inserting conditions. But common sense and common decency unite to require that I at least be obvious when I am inserting conditions, so that you recognize that elements of risk are being shifted onto your shoulders. If I am guilty of the use of ambiguous or vague language, I have not accomplished my agenda. That language will be construed as the language of a promise, not a condition. That's all there is. It's basically a factual inquiry applying that one rule to the resolution of doubtful instances. We are now passing to the second stage of our analysis. Once you have isolated the conditions in the bargain, what is their impact? As I stated at the beginning, every condition modifies a promise. It either inserts a contingency which must either be satisfied or excused before liability to perform the modified or dependent promise. It's a useful term. We call any promise that is modified by a condition dependent, telegraphing to us the message that liability to perform on that promise is dependent upon the elimination of the condition. So the impact, if the contingency is one that must be eliminated before liability on the dependent promise will mature, then the impact is that of a condition precedent or concurrent. The other possibility, of course, is that the impact of the condition is that it will discharge and extinguish what had until that moment in time been a fully matured obligation to perform. That is the impact of the true conditions subsequent. Now, I'll develop this distinction further in the course of the next few moments. Let's begin with conditions precedent. They are by far the most commonly encountered on the bar examination. Simply stated, a condition precedent is any contingency which under the terms of the bargain must occur before there is an absolute present duty to perform the modified or dependent promise. To determine if a contingency is of a precedent nature, ask this. If you translate whatever the language of the problem is, and it comes out to have this meaning, one of the parties has just said to the other, I am not liable on this promise until. I am not liable on this promise until. And here insert the stipulated contingency. That is the litmus test for a true condition precedent. Now let's take some examples. Conditions of satisfaction are the most commonly tested examples of conditions precedent. We can begin by a condition which calls for the satisfaction of the other party with the performance of one of the traders as a condition precedent to the other party's obligation to pay for that performance. Let's take an example. Suppose that in our contract over here between A and B, let's give them human names, it's always much nicer. Fox is a house painter by trade and calling. Brown owns a home right here in greater Los Angeles. One day Fox approaches Brown and says, for $500, I will paint your house. That's an offer. Brown responds, I agree and will pay you the $500 provided I am satisfied with your work. Have the parties formed an agreement? Assuredly, they have not. That was hardly a mirrored image reflection of the offer. Brown, seeking to shift all element of risk in the transaction to Fox, sought to make the promise to pay dependent upon his satisfaction with Fox's performance. Notice that what has happened in the counteroffer is that we now have fixed a time and order for performance, but yet we have not formed an agreement. But let's suppose that Fox is confident and says, I agree. Now there is an agreement, but is the bargain a contract? Well, of course, it depends upon whether there's bargain for legal detriment on both sides of the exchange. One analysis of the bargain so far is to conclude that Brown, the homeowner, has given an illusory promise. His statement, I will pay you $500 provided I am satisfied with your work, if it were construed to mean that he would pay only if in his unfettered judgment he determined that he would be satisfied, we could say that he said, I'll pay you if I want to. That would be an illusory promise, in which case there would be no contract. But remember the modern rule that courts favor the reconstruction of events at the formation stage so as to conclude that a contract does exist. And the way they would accomplish that would be to impose upon Brown an implied duty to exercise his judgment of satisfaction in good faith. Once that is accomplished, we have an executory bilateral contract. Who goes first? Under the terms of the bargain, clearly Fox, right? So from a court's perspective, we fix the time and order of performance. Also from the party's perspective, they have used the machinery of an express condition precedent to allocate all of the risk in this transaction to the house painter, Fox. That's a very risky deal. Fox paints first, Brown pays if and only if he is satisfied with the work. Now, because Fox is in such a vulnerable posture, whenever the contract calls for me to perform first and then await your personal satisfaction as my adversary in the transaction before maturing your liability to pay me, you now understand the common law rule that if the subject matter which has been made the object of the condition of satisfaction is not personal, then a level of performance by the party who had to perform first, which would gratify the reasonable party, the reasonable person's expectations, will mature, satisfy the condition of satisfaction, right? Even though in good faith and subjectively the particular party, Brown, is saying he is not satisfied. Right? So if Fox achieves a level of performance that would gratify the expectations of a reasonable person, under the dominant common law, that would satisfy, mature, the liability to pay the contract price of $500. Well, is this a personal subject matter? They like to ask these questions because it involves a discussion on our part. There is no litmus test for what is a personal subject matter, but there is a guideline. If the performance is dominated by qualities of taste or aesthetics, then courts are willing to concede that it is of a personal nature. By contrast, if the performance is dominated by utility and function, it is something which we can objectively look at and determine that it does work, or it does service, or it does do the job, then that is regarded as a non-personal subject matter. A house painting contract calling for the painting of the exterior of the house would probably be deemed non-personal. And so even though there is an express condition precedent to homeowner Brown's liability to pay, a level of performance by Fox which would gratify the expectations of a reasonable person suffices to remove the condition precedent. But of course we could take another example designed to illustrate when only literal satisfaction will work. Recently, I was giving bar review lectures in Northern California and had discussed this matter when, at the first break, I was approached by an individual who introduced himself as a person who had substantial talents as an artist. And he put a very intriguing proposal on the table. He said that if I would pay him the sum of $5,000, he would sculpt a bust of myself in the heroic classical style of the Italian master Verrocchio, which would capture the essence of my personality for all time as a patron of law and learning. I must say I was intrigued, but I did not accept his offer. Instead, I told him that I would pay such a sum provided I was satisfied with the likeness. That was a rejection counteroffer. And yet he was very confident. He agreed. Now, rather clearly, I think any court would grant that the subject matter of a personal likeness is dominated by qualities of taste and aesthetics. Therefore, through the use of an express condition precedent, I fix the time and order of performance. Who goes first? The sculptor performs first in time. Not only that, but I shifted all element of risk in the transaction. He must fully perform on his contract promise before I am even potentially liable to pay for it. But his full performance does not make me liable. Instead, there is the express condition of personal satisfaction. Suppose we would gather together in 6 months for the great unveiling, and hundreds of you stipulated that it was a magnificent likeness. There was only one dissenting opinion, mine. If I am in good faith, the artist will learn a bitter lesson. I have no obligation to pay under the terms of the contract because my dependent promise will never mature. Second, if I say, take the thing away, I'll have nothing to do with it, I could have no liability on a theory of quasi-contract, for as you will see in your remedies review, I have not been unjustly enriched. Finally, there could be no recovery against me on a theory of promissory estoppel, because a promise to pay if and only if I am satisfied is not a promise that had the foreseeable quality of inducing detrimental reliance. One could not reasonably rely on a promise which advertises insecurity. Insecurity. But I said I had to be in good faith. Suppose that on the day of the unveiling I were to confide to my wife that I really found it a flattering and acceptable likeness, only to have my wife tell me that if I was going to spend $5,000 of our paltry savings on such a ridiculous subject matter, then I must really like that bust. It would be the only companion I would have for the rest of my life. And therefore, forced to choose, I come into the room and announce that I don't like it, though it isn't so. Then I will be liable for the full contract price, not on the theory that the condition has been satisfied, but on the theory that it has been excused. Excused. Right? Because again, there was the covenant that I was to make my judgment, implied though it is, in good faith. Right? I breached the contract when in bad faith I feign a lack of satisfaction. There is another type of condition of satisfaction. We had a brush with it last night in the final examination question we looked at, and that is one that inserts a condition, an express condition of satisfaction of a designated third party as a condition precedent to maturing the liability of one of the traders. Remember last night we had the builder and the homeowner. The builder, under the terms of the contract, was to go forward with the construction of the home in monthly installments. Right? Who went first? The builder went first. But the homeowner was to then pay for the cost of materials and labor incurred in that monthly progress, provided an architect issued a certificate indicating that the work conformed to architectural plans and specifications. Now, the purpose of placing the architect between the builder's performance and the homeowner's payment obligation is manifestly to shift all of the risk of the transaction of defective or deficient work to the builder, and to shift the risk in such a manner as to make the homeowner have no liability to pay until this designated third party has exercised the crucial matter of judgment. Now, what happens if the parties have made such an arrangement? Well, we had no problem with it last night because factually we were told the condition was satisfied. The architect had issued her certificate. But if she had refused to issue the certificate, there would be no liability on the part of the homeowner to make the installment payment. He had no such liability unless. He had no liability to make that payment unless there had been an issuance of the certificate. And until that happened, he was not liable. Now, what if the builder could bring in 5 other architects, each of whom would testify that in their professional judgment the work was quite satisfactory? Their evidence is legally irrelevant. The party's bargain was trusting in the judgment of this designated third party, and that is the law of the contract for them. And so if they give you facts that indicate that the parties have selected an expert and that expert is refusing to give the required approval, and nevertheless they go on to tell you that other witnesses could be called who would testify that they would, the answer is their opinion is irrelevant. The contract called for this specific third party, and the law will substitute no other. So long as the designated third party withholds her judgment of satisfaction in good faith, therefore the homeowner is not liable. But I've used now, this is the third time I've used the phrase in good faith. Let's pause and think about it. A party can be in bad faith on grounds that do not involve any demonstration of a malevolent motive. The architect would be in bad faith if the reason she refused to issue the certificate is any reason other than her professional assessment of the builder's work. A few years ago, on the multi-state, they had a question that involved an architect who was a social acquaintance of the homeowner. And the homeowner told the architect that he was going to have difficulty raising the amount of money that would become fully matured and liable the moment the architect granted the certificate. The facts then went on to say that in order to give him an additional week to arrange financing, the architect refused to grant the certificate. My friends, that was a bad faith refusal on the part of the architect. Requires no demonstration that he had a malevolent motive. But if he attempts to withhold a judgment of satisfaction of the condition on any ground other than the one conceded to him under the terms of the contract, the condition is excused. The condition is excused, and the homeowner becomes instantly liable for the contract price. And so now we have used conditions of satisfaction to examine conditions precedent in the abstract, and also to understand as sort of a preview how conditions are satisfied, and we've also gotten a peek at how conditions are excused. Let's talk about the topic of conditions that are concurrent. We've talked of conditions precedent. What about a condition concurrent? Well, here's a tip. Almost invariably, a condition which is concurrent in its nature is constructive, meaning implied in fact, or implied at law. It is constructive, implied at law in its origin. Rarely will you find express conditions concurrent. They are used to regulate the time and place for performance when the traders have not spoken to that vital agenda informing the terms of their bargain. Right? The most common constructive condition is this. If A and B, Fox and Brown, form an executory bilateral contract and then say nothing from which we could derive the conclusion as to which of them was to perform first, we could never determine who was in breach unless the law now fixes a time schedule and order for their performance. And we ask this: are the performance obligations of both parties physically capable of being rendered at the same time and in the same place? If they are, then mutual tenders, that's a term of art, tender, T-E-N-D-E-R, means a manifestation that I am ready, willing, and able to perform right here and right now. Mutual tenders of both parties are required as constructive conditions concurrent. Now this is just pure genius. It means that if Fox wishes to place Brown in breach, Fox must manifest that he is ready, willing, and able to perform. And having done that, if Brown does not manifest that she too is ready, willing, and able to perform, we have isolated Brown as the party in breach and the appropriate target for a damage remedy. So if in the physical order, the performances of both parties are capable of being rendered at the same time and in the same place, then mutual tenders become constructive conditions concurrent. Remember, I said there were only three possibilities. Either Fox must perform before Brown, Brown before Fox, or Fox and Brown must perform simultaneously. Conditions concurrent call for simultaneous performance. And the third type of condition, viewed from an impact of the condition upon the modified promise, is the condition subsequent. I've labored the distinction. The operative impact or effect of a condition subsequent is that it will discharge or extinguish what had until that moment begun as a state of present liability to perform. It is very difficult to think up examples of true conditions subsequent. Like a genuine princess, they're exceedingly rare. I gave you one yesterday. I said that a condition subsequent is the most useful tool for preventing my client from ever having to face the demands of an assignee of rights. I merely place an express condition in the contract that declares that any attempt by the other party to assign rights extinguishes all of my client's duties under the contract. The contingency, therefore, is the attempted assignment. The consequence, the destruction of a liability to perform what were otherwise mature duties, makes it a condition subsequent in nature. Now, the real significance of typing conditions for their impact upon a state of present liability actually crosses out of the realm of contracts and into that of civil procedure. So there's frequently a civil procedure crossover ingredient to this question. Because you see, in civil litigation predicated upon an alleged breach of contract, the plaintiff does not allege a claim upon which relief could be granted until in her complaint she alleges the satisfaction or excuse of all conditions precedent and concurrent to maturing the liability of the defendant. At trial, the plaintiff has the burden of proof with regard to any disputed condition precedent or concurrent. And it is the plaintiff who risks the non-persuasion of the court, meaning that she has the burden to preponderate through proof that all conditions have either been satisfied or excused so as to mature and render a matter of present duty to perform the covenant of the defendant she claims was breached. What about conditions subsequent? They are regarded as matters of affirmative defense. Therefore, they enter the litigation only if the defendant asserts in a responsive pleading the existence of a condition subsequent and the allegation that it has factually been triggered so as to extinguish the liability which had otherwise existed. And it is the defendant who bears the burden of proof and the burden to preponderate on the existence and triggering of any condition subsequent. I also indicated in the very first hour that we were together, it seems so long ago, that when we talked of conditions, we would type them not only for their impact upon the promises they modify, but according to their origin. And I said that if you viewed and recalled conditions according to their origin, they were of three types: express conditions, conditions implied in fact, constructive conditions, the conditions that are implied at law. I've been using the terms. Let me clarify them. Express conditions are conditions created by the very language of the bargain. The statement, "I will pay provided I am satisfied with your work," is an express condition. The condition that I am liable unless you attempt to make an assignment of the right to receive my performance is an express condition. They are created by the very language employed by the traders in framing the terms of the contract, and you isolated them when you went through the language of the bargain at step number one. Suppose you don't find any express conditions, or though you have found one or two express conditions, I still want you to appreciate that your quest isn't over. Because lying beyond the presence or absence of any express conditions, there may be further conditions in the bargain that are implied in fact or implied at law. Let's talk for a moment about conditions implied in fact. They are very important. These conditions arise by necessary physical inference from what the traders have reasonably assumed on the day they formed the bargain. You may find an analogy to implied real authority in the law of agency useful. The function of implied in fact conditions is to protect the reasonable moral and physical expectations of the parties to a contract. Therefore, they are never stated in so many words, but they are derived from the reasonable assumption of Fox and Brown on the day they entered the contract. The major condition implied in fact runs from every promisee. Remember I told you yesterday that in a bilateral contract, I am the promisor of my obligations. I am the promisee of yours. And you occupy the same dual position. You are the promisor of your own duties and the promisee of mine. Well, now there is an implied in fact condition running from every promisee to the other party as promisor. And that is that on the day you attempt performance, I will cooperate in good faith in receiving your performance. That is the vital implied in fact condition protecting the moral expectations of the traders. By the same token, any circumstance physically necessary to a reception of the other party's performance is implied in fact. In the hypothetical that we were using between Fox, the house painter, and Brown, the homeowner, there is an implied in fact condition that on the day that Fox shows up to attempt the performance, that Brown will not only allow him onto the property, cooperate in good faith in receiving the attempted performance of Fox, but also that on that date Brown will have a physical dwelling standing. If, God forbid, the night before and without fault of either party, Brown's house should burn to the ground, so that a physical circumstance reasonably assumed is necessary for Fox to do his work doesn't obtain, the failure of Fox to paint the house that no longer exists could never be a breach of contract, because although Fox's duty appeared to be unconditional, it was protected by these implied conditions implied in fact. That's why I say never assume that merely finding that all the express conditions settles the matter. Invariably, there will also be conditions implied in fact hedging the obligation of the parties. Now let me give you an example of how this can work quite dramatically. Let us suppose that we change what Fox and Brown do for a livelihood. Fox is now a wholesaler, right, of citrus fruit. Brown has a chain of retail grocery stores here in Southern California. He also has a large warehouse facility somewhere out in what you all euphemistically refer to as the valley.
Please stop the machine at this point and turn the cassette over for side 2.